Oh, good morning, everybody. Welcome to hearing stream 5 of the submissions and hearings into the proposed Wairarapa Combined District Plan. My name is David McMahon, and before we commence, I think we'll start with karakia, please.
Yeah. Mai te koe maua, rā ki te tā. Mai te aotoa, rā ki te awarapi. Tēnei te hapori awhi, ai taratari. Taratari. Whanau, haere mai te hoki, haumie rie tai.
Yes, thank you, everybody. Hey, as I said, I'm David McMahon. I'm the independent chair of the Joint Hearings Panel, and I'll just ask my colleagues to introduce themselves, starting with
Kia ora tātou, ko Robin Cherry Campbell toko ingoa, from Carterton District Council.
Kia ora everybody, Brian Della from Carterton District Council.
Kia ora koutou katoa, ko kere ana Naira Sims ahau, uri o Wairarapa, and representative of Ngāti Kahungunu ki Wairarapa. Kia ora.
Hello, it's me here to get koutou katoa. Tēnā pe matua ai. Ko Joanne Hayes toku ingoa. I am the representative for Rangitani.
Joe.
Oscar from South Wairarapa District Council. Brian Jefferson, representative for South Wairarapa District Council.
Kia ora, Fraser Marlin, Master District Council. Fraser, Master District Council.
Thank you, everybody. And just to extend the courtesy, we'll start with those that on the other side of the table, starting with our hearings administrator.
Grace McEwen, hearings administrator.
Got Hamish Wesney, reporting officer for the sites of significance topic today.
Solity Robertson, Carterton District Council. I have a small part in the sites of significance to Māori and the Transpower submission.
Thank you.
Kia ora, Becca Adams, at Carterton District Council, and I'm the reporting officer for Historic Heritage. Kia ora, Alice Falloon, I'm a planner at Master District Council.
Morning, Sue Stelvey, a consultant at Carterton.
I'm Matthew Gosling, planner at South Wairarapa District.
Welcome, Matthew.
Chris Dorman, legal planner at South Wairarapa District Council, reporting on coachable trees.
Yes, thank you, Chris.
Kia ora, Russell O'Leary, Group Manager, South Wairarapa District Council.
And the back.
Christine Strong, Master District Council.
Thank you, Christine.
Kia ora tātou, ko Paddy Mason ahau, trustee for the PSG and chair of the Wairarapa Development.
Cora.
Kia ora tātou, tūtahi kei te mihi atu kia koe e tuku i te karakia, tēnei ata, mihi ana kia koutou. My name is Harvey Takaisi. I was employed, or I'm employed by the council as the advisor, iwi advisor, Māori advisor.
Thank you and welcome for coming. And online, last but not least, Morgan.
Kia ora koutou katoa, ko Morgan Fallowfield Tokonga. I am supporting Hamish with the Sites and Areas of Significance to Māori Chapter Section 42A Officer role.
Thank you, Morgan. I'm glad you can be with us, albeit remotely. I understand you had a bit of a wild ride last night on your flight to Wellington and diverted to Hamilton.
Yes, that's right. So I'm joining from our Hamilton office today.
Good. You're coming through loud and clear. Thank you.
Thanks.
Okay, so
Not that off email.
this hearing's divided into three parts, and it's the first of the overlay hearings. So the second part of the overlay hearings will commence Monday and Tuesday. But the focus today is on first of those overlay parts, and they are the sites of areas of significance to Māori, historic heritage, and notable streets. And as indicated, we have Hamish and Morgan on the sites of significance to Māori, Becca Adams on heritage, and Chris Gorman, a new presenter to these proceedings, on notable streets. For those that haven't presented before, the panel likes the Pūtoi officer to take us through their summary statement and to explain the mechanics of the chapter that they're dealing with, so that we understand how those chapters are formulated, how they work mechanically, and what the flavour of those chapters are from a policy and rule perspective. So that's the process we've used in the past and we'll continue to use today. I think unless there are any procedural matters arising, we'll move to the first topic, which is the sites and areas of significance to Murray, and Hamish and Morgan, we're in your hands.
Well, Morgan will take the lead for this morning.
Thank you, Hamish. So I'd just like to start off by reading the summary statement for the sites and areas of significance to Māori chapter. And if it's okay with you, I'd like to start on page 1 in section 2, the overview of sites and areas of significance to Māori chapter.
Fine.
Okay. So the operative Wairarapa combined district plan, the operative district plan, contains provisions to protect sites and areas of significance to Māori, which are identified in a schedule to the district plan. This schedule contains 44 sites and areas of significance to Māori, 43 of which are located in the Marston district and 1 in the Carterton district. There are no sites or areas of significance to Māori identified in the South Wairarapa district in the operative district plan. The review of the sites and areas of significance to Māori provisions concluded the lack of identification in the operative district plan of sites and areas of significance to Māori in the Carterton and South Wairarapa districts is limiting the ability to protect these sites and areas. The review also identified some issues with the efficiency and effectiveness of the policies and rules in the operative district plan, including potential restrictions on the use of land with sites and areas of significance to Māori. The key resource management issues for the sites and areas of significance to Māori are sites and areas of significance to Māori can be lost or degraded if inappropriate land use development or subdivision occurs without considering the value or importance of the site or area. The proposed district plan contains a sites and areas of significance to Māori chapter, which includes provisions for the protection of sites and areas of significance to Māori. It includes a suite of policies for sites and areas of significance to Māori and a rule framework providing for the reasonable use and development of land as a permitted activity subject to standards. Through this framework, development, subdivision, and certain types of land use activities require resource consent to assess the effects of the proposal on the values of the sites and areas of significance to Māori. The proposed district plan lists scheduled sites and areas of significance to Māori in Schedule 4 and identifies these on planning maps. Identifying sites and areas of significance to Māori has relied on the cultural expertise of iwi and hapu through the review of wāhi tonga and archaeological sites in the districts. The proposed district plan includes the addition of 100 new sites and areas of significance to Māori in the South Wairarapa district to the schedule of sites and areas of significance to Māori. It also includes the remapping of 44 sites and areas of significance to Māori in the Masterton and Carterton districts, including the extent to show an area, a polygon, rather than a site or a point in some cases. Is it important to note that there may be some other sites known only to Rangatani o Wairarapa and Ngāti Kahurunu ki Wairarapa that are not identified in the district plan?
Thank you, Morgan. We'll just ask you to pause there and before we get into the matters raised on submissions, I think the panel would benefit from some explanations on some of the background. Firstly, what's your understanding of the absence of any listings of SASMs in the operative plan within the South Wairarapa district? Why did that occur, come about? Do you have any understanding of that?
So if I'm understanding the question correctly here, you're talking about where there's sites not identified in the operative district plan and why that's the case?
Yes, and particularly no sites in the South Wairarapa district plan and only one site within the Carterton component.
Okay.
Compared to 44 sites or 43 sites in the Masterton area.
Mm.
Do you have an understanding of how that eventuated?
I don't, but my colleague, Mr. Wisney, may be able to assist with the answer to this question.
My understanding, and Russell and Harmy may be able to elaborate from their previous involvement, that there was differences in between the previous councils at South Wairarapa and the iwi authorities regarding the identification of those sites. So it's going back over 15 years. So that's probably just a difference of opinion at that point in time.
Okay, a difference in opinion as to the need or the ability to map these areas.
Sensitivity of the information around identifying the sites.
Okay. To be clear,
Can I add to that?
absolutely. You should come up to the front, Harmy. And Russell, if you want to come up too, then fine.
There was a major issue for Māori is site-specific identification, but also it's these same issues that you're grappling with now in terms of how do you, the impacts on landowners when they become more, aware or they have knowledge about the extent of sites on their properties.
Yes. So was that
It's both. I think council was protecting the issues around for themselves around how to impose protection mechanisms. Council and I mean I've been involved with South Wairarapa Council for all the time I've been in Wairarapa, which was probably about 40 years. And the original planner, a guy called Ross Smith that I was involved with, he used to have a historic places inventory in his bottom desk, and that was the sort of how the council saw that they were taking care of things. You might be able to hear.
Was there an agreement between the council and the iwi that was the best approach at the time?
Well, the iwi side of things is the difficulties around having point specific. The thing is with sites that, I mean, which was the reason why I became involved today. There's 300 sites in Wairarapa, absolutely no protection there under the district plan. So it relies on Resource Management Act, relies on the iwi relationships with council, and it relies on Heritage New Zealand to deal with those. And it's I
understand that. Russell, did you want to add anything?
No, not really. I think Harmy's articulated it quite well, and just consideration factors at play at that time, pre-2011, pre my time, is that careful navigation of around any decision to locate and identify and record, yes. And liaising with iwi and hearing their views around sensitivity and the potential risk factor or the heightened knowledge factor in that with identifying the sites, it may raise public's general curiosity factor. So there was a cautiousness approach taken at the time.
Raises a couple of questions in my mind and possibly in the panel's mind too. Firstly, with the proposed addition of 100 new sites, all within South Wairarapa, what's changed to now enable the council, allow the council to include those sites, given the previous issues of sensitivity and disagreement about how sites are shown? What's changed?
Well, I think
change of thinking.
the way that they're going to be entered onto the into the district plan, and so there's a degree of buffer around sites.
The method of which they're shown. What's changed in terms of the sensitivity
issues? Well, sensitivity issues will always remain, especially when there is a non-family member with private land, and there's issues around identifying.
Well, can you help us then by explaining how these 100 sites have been identified? What was the process and methodology that you undertook?
Well, there's
and over what time period?
Combination where the data came from. Is that like where the data came from?
I want to know. Got a part of the operative district plan that has zero recognition of sites of significance. Now we've got a proposed plan that shows the same area with 100. So you obviously were commissioned. Let me just finish the question, Harvey.
No.
You were obviously commissioned to do some work to identify sites and presumably to consult with iwi to assist you in the identification of those sites. Can you explain how that process worked and how you undertook that exercise?
Well, the first thing that we've always known that there are more than 300 sites in South Wairarapa that didn't have protection under the district plan. And those are just the New Zealand Archaeological Association sites. And they extend from.
When you said that, so these sites were already registered with the
they were already
society.
Known,
is that what
publicly known sites.
Been known sites.
Yeah.
And there was a record of those sites held somewhere.
Yeah.
Okay. Thank you.
So that's that was primarily the issue. I've been involved with the district planning in South Wairarapa for a while. At one stage, Heritage New Zealand or Historic Places Trust at the time objected to the fact that there were no sites recorded on the district plan, and they applied for a variation, which never occurred. There's been quite. I've got the Waitangi Tribunal report.
Yeah, look,
but there's been a lot of discussion about the need for protection of those sites.
I'm not arguing about that. What I'm trying to ascertain from you is the timing and the process and the methodology that you undertook to identify 100 of 300 sites within the South Wairarapa. It's a factual question.
I've been mapping polygons of these sites for quite a while, but what actually transpired was that there was a cell tower that was put up at Tora, last year, I think it was last year, and the council were concerned that there'd been no done on the fast track process. So I got called into invited to present at the Māori Standing Committee meeting and presented this work that I've been doing for quite a long time around heritage protection, how it might be better in terms of our values, iwi values, and the Māori Standing Committee agreed with me, and they then supported the work that I was doing. So that was the South Wairarapa Māori Standing Committee. So that's how actually I got involved with this project.
And when was that?
There's a date on it.
No, I mean, we're talking in the last 2-3 years.
Yeah, talking in the last 2 years.
Yeah. And was there consultation with iwi and individual hapu about particular sites? Did you consult with them to get nominations or to see what their feelings were on the inclusion of particular sites, areas?
It's what I'm aware of. There was one meeting that was called here in Carterton, where I was presented, and it was both the Māori purposes proposal and also the sites of significance proposal was presented at that meeting.
The reason I'm asking the questions, and I'm trying to be difficult, is I want to understand how robust and how robust the collection of information and the identification of sites has been, so that we can make the appropriate decision to include them or not include them, and to deal with the rules that affect those sites.
Well, the collection of information, in my view, is really robust, and that is because they have gone through a whole process with the NZA, New Zealand Archaeological Association. So all of that process of identifying sites, and I actually was involved in the upgrade of that data, and also other sites are well known, such as Kupe's Sales. Those sites are well known. Canoes well known to our people, and also I use survey plans. I've used survey plans, and early survey plans identify sites that were in the 1860s, that our places where, I mean, there's cemeteries, urupa, that are on these survey plans, but they don't exist. They've just been drawn in. They don't exist as a title in anywhere. So there's that process of collation of data, and my use of that has been has been very
understood. Are there any of the 100 additional sites on the South Wairarapa not on the New Zealand Archaeological Association list?
Yeah, there are.
There are.
Yeah.
Okay. So how were they identified?
Well, I've just said that from knowledge, like for instance, Kupe's Sales.
Okay.
Those Kupe sites, also from plans, survey plans, early survey plans. I'm talking about 1860s.
Yes.
Yeah.
Yes. And okay.
So I haven't used any data that hasn't had some sort of evidence base to it.
I'll just see if my panel members have some questions, but before we do, just one final question to finish this. There are obviously other sites that are of significance to Murray in the South Wairarapa that aren't included in the proposed plan. You talked about some 300 sites, of which 100 have been identified. What's your understanding of their sensitivity to, or their risk?
I think all of those 300 sites are included in the 100 polygons, whether it be polygons or other. I think all of those are represented, but they're not the only ones represented in those sites.
Right.
Yeah.
Okay, Joe, I think you've got a question.
Yeah, I have a question, Hami. So the work that you've done, was that, or did you have any support from the Rangipane whānau that also held knowledge of sites of significance? Region.
Yes. I mean, Horipo and I have worked together over a long period. When they saw the way that I had mapped some of those sites for South Wairarapa, they asked, and well, that I do the similar, go through a similar putting buffers. So I worked with them on the Masterton and some of the Carterton sites, I think, but definitely the Masterton sites. That was at their request. But Hoiripo and I have worked on the South Wairarapa sites, responding to heritage issues for a long time.
Kia ora, and to you, Mr. Chair, I asked the question to ensure that the panel understood that it just wasn't about harming in the archaeological sites. People that did this work, it was right across both iwi. Kia ora.
Any further questions of Amy at this point?
Yes,
Alistair.
one. Amy, thank you for clarifying the 300 into the 100, so that clarifies it for me. But I'm really interested in how the part that there are known sites only to Rangatani and Kaununu. How do they get any protection under a district plan, which is all about being open and clear? If they're not on the plan, how is it that they would be known for any landowner, or what's your understanding of how that would work?
Well, I think that's probably better question put to, but can I say that the way that especially those coastal sites work, because I think people like to tell us that we couldn't survive on anything else but kumara, and we couldn't live, way inland and something, which is not supported by some evidence as well. But there's a lot that's captured in the polygons that will then allow other sites to be identified sites, for when the planning issue is.
So would it be fair then to say that within your polygons, there are sites that are known only to Rangatani and Kaununu within the wider boundary that covers those very sensitive sites?
I'm sure that there are.
Are there other sites that are equally as sensitive that aren't covered? And therefore, my question is, how would we, because the district plan is all about rules.
Yeah.
So how do we protect those really sensitive sites? And it's one of those questions about what you.
Yeah. And I'm aware that some have asked for certain sites to be included. The areas outside South Wairarapa, I think there's been some genuine interest in doing similar, work on those sites. But if you're talking about sites within South Wairarapa,
across the Wairarapa, well, if I just read the line, it says it is important to note that there may be other sites known only to Rangatani and Wairarapa and Ngāti Kaununu, not identified in the district plan, and it's those sites that I'm wondering, how do we give effect to protecting those sites if nobody identifies those sites?
Yeah, and that's fine, because those sites may actually be ones that they don't want to disclose in a public, in this manner. So that's fine. I mean, those are issues that I guess are between iwi and council. And I'm not sure what sort of plans.
Understand what I'm trying to ask? Yes.
Yeah.
I understand exactly. And the other way, so there's the identified sites in the district plan, and then there'll be the other sites which are not identified. The way that they would be protected is if the activity triggers resource consent for another rule under the plan. So an example is orphan farms need a resource consent, or a subdivision, and if it's notified, then the councils will notify the iwi authorities of this particular proposal, and the iwi authorities through that mechanism would be able to make a submission saying, hey, there's some significant sites here.
If
it's not notified, then that's the challenge in terms of there's a risk there that there may be an activity which could have effects on those significant sites. But I think that from my perspective, those other sites, it would rely on the relationship iwi have with the councils and also the wider community around those sites.
It's not going to be the council relationship, it's going to be the landowner relationship with iwi. And what, you know, if you take Jeffy's farm, for example, he's got a long-standing relationship with local iwi down on the coast. But if his farm is sold to somebody from America, or they won't have that relationship, so they may well do things on land that there's no relationship and there's no shared knowledge. So what happens in that?
Yes.
And that, to me, that's the risk.
That is the big risk.
Well, not in relation to that farm, because most.
Yeah, it was just an example.
That's not example.
But, this was not about sites that are unknown. These are about sites that are publicly known. We know about these sites. This is about them. It's not about. So, isn't there a sense that you can take care of the ones that you know about, and then deal with the ones that you don't, and which takes care with a big proportion of areas where they're potential sites, whether they're known or not known.
So I suppose for me, to clarify this, taking what Hamish said, that is the risk. Is it your understanding then that the iwi and hapu that you've worked with are accepting of that risk?
The risk that
unnamed sites may well be damaged unintentionally. Because that's the risk.
So this is
sites that are not protected by the district plan, Harmy, are known by certain entities. Is the risk acceptable?
So, as opposed to the risk of not having sites that are known being damaged through the same way, that they are not.
Sites that are known are protected. Don't have to go through a consenting process because they're identified.
Yeah.
These are about the last statement of Morgan's 42A that says it's important to know that there may be other sites known only to Rangatani or Kahanunu that are not identified in the district plan. Hamish said there's a risk associated with those, and the councillor's question is that risk acceptable to iwi?
Yeah, so I think that it's an easier risk to manage when we don't have to manage the ones that we know about and they're not taken care of. So that is the risk that I think that iwi can manage. I mean, it's like we having to deal with sites that we shouldn't have to, because they're known, recorded, and they should be sitting somehow. There should be some mechanism for protecting them, and that will help iwi to deal with I think with those other issues where where they're not where they're less willing to share that information.
We've got one additional comment might just help in terms of that risk assessment. Back in 2001 and initially discussing Palmy and Haripo around where are the significant sites, what are the most significant sites, where are the threats to those sites. The South Wairarapa coastal environment was identified as the key area, which is the gap in the operative plan. We've already acknowledged that there's none in the operative plan that's identified. So if needed to prioritise, where do you identify and map first? South Wairarapa coast, Lower Valley was prioritised because of the significance of those areas, the concentration, and add to the sum if I've misunderstood as well previously, that's where there was that greater action. So and the threat to potential damage. So that Harmy's highlighted examples of a cell site on the coast near Tora. There were some other works earthworks that were done on other sites around the coast. So that area boasted the significance, but also the threats for the areas. So that's where we've prioritised. So there's potentially other areas on the valley floor, but
this goes. I mean, in Section 32 terms, that this goes to what's known as the risk of acting or not acting, and so in this case, risk of acting. But Hammy was suggesting that of the 300 known sites, that they're all captured through the polygon approach in terms of the 100 sites that are identified.
Correct.
You can confirm that?
Yes. Yeah. So if you look at the maps, there's some larger areas around the coast, which I understand there's a number of individual sites within those larger areas.
That's useful. Now, Harmy, the final question I've got is, let's forget about South Wairarapa for the moment. The 40 of the 43 sites from Masterton and the one site in Carterton, were you asked to reassess those or identify any additional sites from the operative plan to be carried through into the proposed plan?
I think there's some submissions around.
No, my question, please listen to the question.
Yeah, I hear,
Were you asked to,
well, I was asked to consider that, well, okay, this is before I haven't, no, I haven't.
that's fine.
I was asked to map some of those sites by Rangitani.
Right. The chapter 43 plus 1, 44 hasn't changed, has it? You haven't identified, have you identified?
No.
I can just elaborate.
No, it was purposeful. I couldn't spend the time doing.
Fine. Yep.
Joseph Patongaroa was engaged to understand he was involved in the original identification of the 44 sites in Masterton and Carterton. And so he was re-engaged in, I think it was late 2021 or early 2022, to remap them in the same methodology that Mr. Tawhiti has used. So at the moment in the operative plan, they're all identified as single points. Mr. Patongaroa was asked to remap them as single points or areas or polygons, and work with Mr. Tawhiti to then capture those existing sites in that same way.
Christine, would you mind just turning that off, please?
Off at the wall, Christine.
Okay, so Hamish, so with the work that Joseph did, were any of those sites converted into polygons? Okay.
I don't know the exact. I can look it up. I don't know the exact number, but there were I'd say from memory about half of them were changed. So the ones which are some of them are monuments, others were par and so on. So the ones that were par, instead they changed to polygons.
Okay. Panel, did any further questions to Hamish, the operative district plan or the approach that underpinned in the district plan in terms of the identification of sites? Thank you. Morgan, we'll come back. Oh, sorry. Morgan, sorry, yes, we'll come back to you. Before we move on to the submissions, can you take us through the mechanics of how the policies and rules for the 7th chapter work?
Yes, sure.
We've got a copy of the chapter for 10 pages that forms the chapter. Able to take us through the policy approach and the rule approach?
Yes, sure. So I guess to summarise overall, in the operative district plan, there were no permitted activities. So any activities within a site and area of significance to Māori required a resource consent. And now in the proposed district plan, there are some activities that are provided for as a permitted activity and others that need a resource consent. So in the objectives, there are 3 objectives. So recognising sites and areas of significance to Māori is the first objective. The second is providing for kaitiakitanga. The third is protecting sites and areas of significance to Māori. In the policies, the first one is to identify sites and areas of significance to Māori. The second is to protect and maintain sites and areas of significance to Māori. And the third is to allow limited earthworks within sites and areas of significance to Māori. Over the page, Policy 4 allows limited earthworks within sites and areas of significance to Māori. Number 5 is to protect the values of sites and areas of significance to Māori from inappropriate subdivision use and development. Number 6 is to avoid removal or destruction of sites and areas of significance to Māori. Number 7, to support landowners to manage, maintain, preserve sites and areas of significance to Māori. And 8, to engage with tangata whenua on sites of areas of significance to Māori. Finally, the last policy is to promote access to sites and areas of significance to Māori for customary activities.
Can you take us through how that translates into the rules that control activities?
So those policies provide guidance for those rules. So there's specific rules related to activities, and within those activities in certain zones there's a permitted activity status for some activities, and then if those standards cannot be met, a resource consent would be required, and the activity status of that consent is stated in the rules below.
Seems that apart from Rule 1, the remaining rules apply to, well, Rule 1 applies to all zones. The remaining rules apply to all zones except the settlement zone. What's the rationale for the settlement zone being excluded? And what rules control any SESMs that are on the settlement zones, or is there no SESMs in the settlement zone?
So I addressed this from memory in the Section 42A report as well. My understanding is that in the settlement zone, it was a mostly urban area that had already been modified to some extent. And so the settlement zone was excluded from sites and areas of significance to Māori, but Mr. Wesney or Mr. Tifiti may want to expand on that.
So no, Morgan's captured that well in terms of the reason, and because most of the settlement zone is located in the coastal environment where there are, so we're talking about Ngāwee, Riversdale, Castle Point as a few examples, that most of the sites of significance to Māori are also located in that area, and so there is a little bit of overlap in a few places because of the high level of modification of properties within the settlement zone. It's not considered appropriate to apply the same level of controls to settlement zone.
I understand that, Hamish. Be a high level of development in the urban zones also, yet they don't appear to be excluded.
Correct.
That's because there are no SESMs in urban zones, or what's the reason?
There's a handful of sites in the urban zones, so on Marston, for example, and it's there's because of the heavy modification on those sites as well. But those sites that are identified are considered significant. That any future work should be considered, and that's primarily in terms of future buildings and structures.
Yes. So the all zones would capture the urban zones as well.
Correct.
What's the rule? Where do we find the rule framework for the settlement zone then?
There are no rules for the settlement zone for SESM apart from the first rule around maintenance.
Okay. So is there a reliance on the coastal zone or what's?
No, it's just that because of the level of modification of the settlement zone.
Can I make a comment?
Sure.
So with the settlement zones, I think we'll be relying on the existing method for. I mean, they still have all those settlements from Lake Ferry right down to Ngāwee are built on what was previously historic kāinga. And I think we rely on the fact that they are known sites, and Heritage New Zealand will still have the same, identification for those sites. They will still carry on.
Yes.
We talked about sort of non-interrupted continual use of a site, and so some of those settlement zones would be those, wouldn't it? The ongoing human habitat, albeit obviously the shape and style of buildings has changed over the 150, 200 years. So, but it's that continual use throughout history that gives it those protections. But that is fair. I remember we talked about that. Yeah.
Thank you. Morgan, the policy number 6, P6, talks about the avoidance, removal or destruction of sites and areas of significance to Maori.
Yes.
And then the beginning of the policy says ensure that the adverse effects in areas of significance to Maori are managed. And then there's a sort of hierarchy, if you like. A, avoiding, B, avoiding to the greatest practical, and then minimising, remedying, and whatever. How was that? How was that hierarchy developed? And is the word avoid in the policy the right word, given there's a sort of a menu of approaches, not just avoidance in the policy? And also note that the activity status avoidance is discretionary activity under Rule 8, I think. Yes. So I just wondered, not sure how your involvement goes back into that. It just seems that there might be some perhaps tensions between the title of the policy and the wording within the policy, and perhaps the activity status also. Would you like to comment on that?
Yes, so my involvement in the policies doesn't extend that far back to when that was drafted. Just wondering if Mr. Wisney may want to comment on that.
I think that it is it's like all the policy titles in the plan. They're a shortened or simple version of what the policy is, but it doesn't pick up the finer detail of every policy. So I could see how you could read the title where it just refers to avoid and meaning that's that only outcome sought, where the policy does provide for pathways for not avoiding but minimising or remedying the effects. I'd need to just check whether there's scope to amend the title to change.
And then the question would be, what would the replacement title be?
Correct.
Okay. Is that something we can leave with you and Morgan?
Yes. Yep.
Yes.
Think of potential with Transpower's submission point.
That was all the questions panel I had on rules policy. Brian.
I just had one, and I'm not sure who can answer this, but I guess reading the policies, to me, policy 7, most important, around supporting and managing with landowners. I don't think it's probably our role to do anything about that, but could I ask Harmy if is that working?
I'm sorry, can I see that?
Oh, yeah.
I don't.
Page 5, Harmy.
Yep.
Yeah.
Really captures it inside P7 there, Russell. I guess I'm speaking from experience here, but and I'll have it mentioned.
Yeah. So one of the things that we've talked about in the past is rate relief, you know. It's probably council can't, well, may not be, but it's as important to preserve and to support the owner, the landowner, to, you know, value and preserve what's on their land. So there have been, I think, suggestions around how the consents, doing consents. I think I heard that. I'm not sure of the details though, Brian, but I think it is. It's we can't do it. You can't do it without the active. And I mean, it's not as if in all the, you know, my involvement with, I mean, the subdivisions generally, very few have been prevented from going ahead because of, you know, the heritage when we've been actively managing them. So I think in the last maybe 10 years or so, but it's really important to have that support of the landowners, and in one sense, they identifying them gives them certainty as well, and so I mean I think that's and how they can manage their land around knowing, you know, where these sites are.
I guess it gets back to Alistair's questions about the unknown.
Yeah.
If the landowners are aware of the, you know, a lot of them may not want to, if they identify anything, say anything, because they're fearful it might hinder what they want to do in the future.
Yeah, it's fear of the unknown, isn't it? But the reality is that it hasn't been the case. No. Yeah. There's always been, you know, a way of resolving.
Yeah.
You know, you can't protect them without this of the landowners, but it needs something a bit more behind it, you know. So than what's there currently.
Thank you for that. There's no further questions. We'll return to you, Morgan, and if you could take us through the statement starting at paragraph 12.
Yes, sure. So the matters raised in the submissions, a total of 23 original submissions and 115 submission points, and 11 further submissions, 96 further submission points, were received on the sites and areas of significance to Māori chapter. Submissions were generally supportive of the sites and areas of significance to Māori chapter. Those that were opposed generally opposed the approach to the sites and areas of significance to Māori overlay applying to private land. Where other amendments were sought, they were to support specific outcomes or provide for specific activities. Paragraph 13. As a result of submissions, a range of changes have been recommended and are summarised below.
Oh. Don't know if you can hear us, Morgan. You've just frozen on the screen.
Do it separately.
You want to carry on?
Technology for you, before you go to threes.
I think Morgan was up to
13A.
yeah, listing out the bullet points. So whether the chapter introduction inserting text after paragraph 7 explaining areas of significance to Māori extents are either shown by an area or a point in some cases.
Yes.
Inserting definitions of Wairarapa, site and areas of significance to Māori and archaeological sites. Amendments to policies 5 and 6. be more enabling and to insert Macron in Mataranga Māori.
Yes.
And then amendments to Rule 2 to clarify that it's an existing RMA legal instrument and inserting a new provision relating to land disturbance for maintenance and repair of existing gateway utilities and renumbering Rule 5 and inserting RMA into Rule 7.
Yes, and Hamish, they were all in response to submissions, weren't they?
Correct. And then in response to the pre-circulated expert evidence, I've read the respective evidence submitted in relation to the sites and areas of significance to Māori, being that of Tom Anderson for the telecommunications companies, Anthony McLeod for Transpower, and Dean Raymond for Heritage New Zealand. I note that Mr. Raymond's evidence on behalf of Heritage New Zealand, Heri Tonga, is comfortable with the recommendations in the 42 report. So Mr. Anderson's evidence, I've read the evidence submitted in relation to the sites of significance to Māori, chapter from Mr. Anderson on behalf of the telecommunications company. I acknowledge that Mr. Anderson agrees with one of the Section 42A report recommendations. It appears that the matters which remain in contention for the hearing are providing greater clarity as to what an RMA legal instrument is in Rule 7. From my reading of Mr. Anderson's clarification as to what is defined as an RMA legal instrument, and additional wording to include in the permitted activity under the National Environmental Standard or an activity that's otherwise permitted in the district plan. A National Environmental Standard. Morgan can pick up.
Back, Morgan. Hamish has started reading the, and I think he's got to paragraph 17.
Start with paragraph 17, Morgan.
Fantastic. Thank you.
This is the issue about Mr. Anderson and the what's a RMA legal instrument. So if you want to kick off at the beginning of 17.
Okay, thank you. And apologies, I'm not sure what happened with my internet connection there. So 17, a national environmental standard or a rule under the district plan could be considered a RMA legal instrument. The reference to an existing RMA legal instrument in SASM R7 relates to a new building or structures, including network utility structures that are located within an approved area. Read in this context, the existing RMA legal instrument must authorise or approve a particular location for a new building or structure, including a network utility structure. SASM R7 notes that a consent notice or a local authority covenant are RMA legal instruments that can provide approval for site-specific locations of new buildings and structures, including network utility structures. These RMA legal instruments have been created through a process approving appropriate locations. Permitted activity rules in a national environmental standard and a district plan do not involve a process for approving an area that is appropriate within a site, an area of significance to Māori. Therefore, these documents do not fit this rule when read as a whole. Paragraph 18. The cost of adding reference to any national environmental standard or rule under the district plan would be the potential modification, damage or destruction of sites and areas of significance to Māori. The benefits of adding reference to any national environmental standard or district plan would be enabling provision of a network utility structures and other buildings and structures. The cost is considered to outweigh the benefits as it would not achieve the objectives of the sites and areas of significance to Māori chapter. The value of protecting sites and areas of significance to Māori include recognising the sites and areas of significance to Māori, providing for kaitiakitanga, and protecting sites and areas of significance to Māori. This is consistent with Part 2, including Section 6 of the RMA, and providing for the relationship of Māori, their culture and traditions with their ancestral lands, water, sites, wahitapu and other taonga, which is a matter of national importance.
Can I just ask you to pause there? I must admit, I'm confused by all of this. Just wondering if there's anything to see here. R7, there's the new buildings and structures, including network utilities that are located in a Schedule 4 site, are permitted where the building or structure is authorised by and located within an approved area in an existing RMA legal instrument. What's the implication of the rule as notified compared to what Mr. Anderson's asking for? Just struggling to understand the difference between the two matters.
So my understanding here is that as it's proposed in this version of the sites and areas of significance to Māori Rule 7, it's confined to an RMA legal instrument, so the consent notice or the local authority covenant, and that is something that's site specific and has been approved through another process, whereas the National Environmental Standard or a rule under the district plan that Mr. Anderson mentions in his evidence could be far wider, broader, more wide-reaching, whereas if it's in a site and area of significance to Māori, we need to understand that the network utility is located within an approved area within that site's or area of significance to Māori.
Okay, I understand what you're saying.
Yeah.
Do you think the wording in A actually delivers on the intent? You say in paragraph 17, a national environmental standard and a rule could be considered an RMA legal instrument. But then you say later on that adding reference to a national environmental standard or rule would lead to some unintended destruction or damage to sites of areas. So even by not adding the reference to an NES or a rule, based on your first sentence in paragraph 17, wouldn't A cover national environmental standard or rules anyway without it being explicitly listed?
Would you like me to elaborate?
Yeah.
I think that's,
yes, please.
Because I've just gone back to Mr. Anderson's evidence as well to understand what's the issue here in terms of your first question, and he might be able to elaborate. Where in his paragraph 19, he says, I still do not, he's referred to the addition of RMA and the recommendation. He said, I still do not have complete certainty as to what an existing RMA legal instrument is. And he says, essentially, it is not clear to me from the rule whether a district plan is a legal instrument, and as such, therefore, a new building or structure that is otherwise permitted under a district plan or national environmental standard is an existing RMA. So I think if you read those four words, an existing RMA legal instrument in isolation, then yes, a district plan and national environmental standard is an RMA legal instrument because it's the statutory requirement. But I think when you read the wording of the rule in its entirety, where it's a new building or structure is authorised by and is located within an approved area in an existing RMA legal instrument. So an approved area in an existing RMA legal instrument, I think they are the key words in how that rule is written. So a district plan doesn't approve an area in an existing legal instrument. It provides the rule framework. So maybe it's just a rewording to make that absolutely clear that it's a site or location specific instrument. It says this site has already been approved for a building or a structure.
Kind of lose for the site because of the brackets, don't you?
You don't.
Yeah, last three words.
Is in the polygon approach, would there be any area within a polygon where an activity, a new building or structure would be authorised?
Yeah, so this is why this is why there is this rule, because there are subdivisions which have been approved in the last 2-3 years,
Yes.
which have imposed a consent notice on the property, which have identified that that's an appropriate location for a building, even though the district plan identifies the broader area as a site of significance.
Yes, sorry. In the rule framework, would there be any permitted activities within a polygon area for new buildings or structures?
No.
No.
It would require resource consent. So this is seeking to permit something that's already being through an approval process.
Understand. Yeah. Okay.
The wording might not be there in terms of complete certainty from Mr. Anderson's point of view.
We'll take that up with Mr. Anderson when he is after lunch. Okay. Moving on to Transpower now, paragraph 19, Morgan.
I'd just like to hand this over
Yes,
to Ms. Robinson. Yes, please.
Thank you, Mr. Chair. So the first point, 19, which is providing for the upgrading of the national grid. I've read Ms. McLeod's evidence on providing for the upgrading of the national grid, paragraphs 23 to 37, and I've accepted her reasoning for adding a national grid specific clause to SASM P4. And this is definitely in accordance with the national policy statement for electricity transmission. Proximity to sites and areas of significance to Māori. Again, I've read Ms. McLeod's evidence on proximities to sites and areas of significance to Māori. Paragraphs 38 to 47. I agree with her regarding the identification and mapping as set out in the Section 32 report. However, the identification and mapping in the proposed combined district plan is focused on specific parts of the Wairarapa, such as the South Wairarapa coastal environment and the Marsden district. There are parts of the Wairarapa where sites and areas of significance to Māori have not been identified and mapped in the proposed district plan, and that touches on your questions from earlier this morning. I also understand that the sites and areas of significance to Māori have intangible values that can be difficult to spatially define within the plan maps. Therefore, the values associated with the sites and areas of significance are not only confined to the spatial areas as shown on the planning maps. Then in terms of the inconsistency between sites and areas of significance to Māori policies, SASM P2, P3, P4 and P5, that includes the wording visually encroached upon or in close proximity to, and implementing the sites and areas of significance to Māori rules. I agree that these rules do not manage activities outside of mapped sites and areas of significance. However, these sites and areas of significance to Māori policies need to be considered when resource consent is triggered under the relevant zone or district-wide rules. And the proposed activity is located in proximity to, but outside of a site and an area of significance. And for that reason, I've recommended that the policies are retained as worded. And then we get on to the SASM policy P6.
Yes.
Pause,
Yeah, please.
certainly.
I understand your line of argument there, Ms. Robertson, about these policies having application to activities not just within the SASM, but on for any activities that require consent in close by or nearby SASMs. And that goes to the term visually encroached, in proximity to, which appears in policies 3, 4 and 5.
Yep.
The outlier, if you like, or potential outlier, is the term visually encroached upon. That term's only used in P2, I think. What's the rationale for having that policy, that wording in the policy in P2? Because it talks about protecting and paying sites and area of significance to Maori. So this is talking, is this both an internal and an external protection?
So looking at SASM P2, the protect and maintain sites and areas of significance to Māori, and the point that you are making is where it's ensuring sites and areas of significance to Māori are not modified destroyed, removed, and or visually encroached upon by inappropriate activities. There are sites like you can look at now Waka or Kupe down on the coast. It's actually a geographical structure. So what you'd be doing with this is then ensuring that inappropriate or other development around that site then doesn't have an effect on more that landscape aspect of it and what can be visually seen as significant.
So for a fully discretionary activity or a non-complying activity, or an activity outside of SASM in those areas, that policy would be relevant. Possibly less so for a restricted discretionary where the matters of discretion are limited. Take that up again with Ms McLeod this afternoon. Where did you get to?
I got to
23.
23. And this is a policy, SASM P6, which is the avoid removal or destruction policy. And this is the one that we noted that there may be some scope to look at that term avoid at a later stage. And paragraph 23, I have read Ms McLeod's evidence on avoiding removal or destruction of sites in areas of significance to Māori, paragraph 51 to 59. I consider that SASM P6 provides a pathway for those activities that do have a functional need. The effects hierarchy in SASM P6 provides appropriate protection of the sites and areas of significance to Māori, and it will provide for activities that have a functional need. And at this stage, I am still recommending that that policy is retained as worded. However, I'm happy to consider the scope issue and whether we need to tweak it or nuance it a little bit.
Are you talking particularly about policy A?
P6.
A P6A, or are you talking about the entirety of the policy?
I think the scope of the entirety of the policy, if you're going to look at the avoid is there or not, it does link to the other ones because of that hierarchical nature of that policy.
Okay, again, we'll take that up with Ms McLeod. Any other questions of Solitaire? No. Well, back to you, Morgan, just to wrap us up at paragraph 24 to 26.
Fantastic, thank you. So this next section in 5 is recommended amendments in response to the submissions and pre-circulated expert evidence on sites and areas of significance to Māori chapter. If you're okay with it, Chair, could we take that as read and move on to the key matters in contention?
Just before you do, Councillor Plummer has a question on.
I'm really interested to get an understanding of what to the greatest extent practicable actually means.
Sure, is that in reference to paragraph 24D in terms of the sites and areas of significance to Māori policy 6 that you're referring to?
Yeah, it is, but you use the term practicable in a number of the areas in this chapter. And so what are you defining as practicable? And when you say to the greatest extent practical, it's words, but what does it actually mean in practice?
That's a good question.
I thought so.
What I'd suggest is, I know there's a lot of case law on this term, practicable and possible. The two are quite different. Maybe the right of reply, you could tell us what the courts have said about the term practicable and why it's been selected. Thank you. That basis, maybe just take us then to 26 and matters that are in contention.
Okay, so based on the matters raised in the submissions and evidence, the following key matters remain in contention. A, clarification of what is considered an RMA legal instrument. B, uncertainty of referring to visually encroached upon and in proximity to in the SASM policies. That's 2, 3, 4 and 5. C, whether SASM P6 provides an appropriate pathway for the national grid. D, whether the sites and areas of significance to Māori chapter should work with or partner with Rangatane o Wairarapa and Ngāti Kahanunu ki Wairarapa or whānau hapu in both iwi. E, whether the sites and areas of significance to Māori should recognise and provide for the relationship of tangata whenua or owners of Māori land. And F, whether the identification and mapping of sites and areas of significance to Māori is appropriate without landowner approval.
Thank you, Morgan. Just two questions from me. The D and E, what provisions of the chapter do they go to? Are they policies? Is it the introduction, or is it rules and standards that those terms work with partner?
So starting with E, the owners of Māori land was through a submission from the Māori trustee, and I just need to check, but that was right through the provisions from memory,
Yes.
objectives, policies and rules.
And D?
And D, work with partner. Now I think that I'll just need to check exactly what provisions, but I think that was related to the objectives.
I just read that. It was one of the submitters, I think, that, based on cultural, the partnership and the Treaty of Waitangi.
Yeah.
So
Just wondering though, is it at the end, might be the introduction even.
It may be in multiple parts of this.
Maybe just we're gonna probably, are we going for time? We might take it.
Yeah, that's true.
Yeah.
We might take our morning tea adjournment and then you could perhaps check on that with Mr. Wesley in the break.
It's throughout. It's
Throughout on both.
Yeah.
similar on both counts. It's wherever the reference to tangata whenua is through to objectives, policies and rules.
Okay. Hey, any final questions of Morgan or Ruth or not Ruth, Hamish or Hami on the panel? No? No. Thank you, everybody. We are going to take an early morning tea adjournment for 15 minutes. Back at 10:35 to hear from Becca Adams, I think, on the Heritage chapter. Thank you. Hearing is adjourned.